our last session of the fourth day of our 11th International Disability Law Summer School. I want to introduce you to the panel today, and what the topic that they will be discussing is tools and tactics to achieve change, holding our governments accountable. And within that context, we have Silvia Quan, who will speak first on shadow reporting, and after that we have Campbell from Validity and Dmitri Bartenev from St. Petersburg State University, who will talk about strategic litigation. And then we have Roger Lewis from Disabled People Against the Cuts in the United Kingdom, who will talk about direct action. So to ensure that we have enough time for questions and answers, I'm just going to hand you straight over to our panel. So Silvia Quan will talk about shadow reporting.
Okay. Thank you again for inviting me to sit here in the panel. I will try to be brief, and I apologize because the battery of my computer died actually on Monday, so I haven't had access to it ever since, so I only rely on my really bad memory. Sorry for that. So I will try to be brief about shadow reporting, but not only shadow reporting, but other forms of participating in front of the CRPD committee. I think civil society, but particularly organizations of persons with disabilities, have a fantastic opportunity to hold their governments accountable in front of the CRPD committee by shadow reporting, but also by participating in other processes that the CRPD committee engages in, like, for example, days of general debate, also by sending individual communications by individuals or groups of individuals who allege violations of the rights enshrined in the CRPD, and also by requesting the CRPD to conduct special investigation procedures whenever there is substantiated and enough information regarding grave and systematic violations of the rights enshrined in CRPD. So I will focus, of course, on shadow reporting. This is a report on the compliance or lack of compliance of the articles under the CRPD for those states that have ratified the CRPD, of course. And there is a time frame usually, which depends a lot on when the state has sent its report, its official report. So as for today, if my memory doesn't fail too much, the CRPD committee has reviewed around 95 initial state reports and has engaged in its first periodic interactive dialogue with the state of Spain. So it's already initiating its periodic reviews also. In the case of initial reviews, shadow reports should be as exhaustive as possible, should include as many articles as it is possible for those drafting it to do so. And it should be based in information that can be referred to a reliable source. So this is a recommendation we usually make, that when including information in a shadow report, try to include information that the committee members, the committee experts can refer to from a reliable source. Something that is very important also is that many times there is more than one single group wanting to write a shadow report, because different groups might be interested in different topics regarding the CRPD. And I would say in the first place that if all stakeholders, all civil society stakeholders can unify their interests into one single report, that would be fantastic. But of course, sometimes that is not possible. But try to make that effort. And the reason why I usually recommend this is because, first of all, if there are many organizations backing up one report, it is stronger. It gives more legitimacy, and it has some kind of stronger validation to it. And so the committee really appreciates this kind of reports. Second, if it's a comprehensive report, it usually will pick up all the topics under CRPD, rather than reading 3 or 4 reports that are thematic, which are of course important in its way, but in a way also we make a little bit easier the task of the committee to analyze all the topics integrated into one single report. So that is of course one recommendation. The second is to have clarity on the human rights perspective, and even though it does sound obvious, sometimes reports are drafted without a comprehensive knowledge of the human rights based approach to all the articles of CRPD, and sometimes it is a little bit confusing whether those who are drafting the report are really in favor of CRPD compliance or no. When we think of Article 23, for example, whether there might be restrictions in legislation and in practice also in relation to certain types of practices which are socially accepted or in major way. There might be some confusion to the real meaning of each of the CRPD articles. And I would add to that in this way, I would link it with the participation of the representatives who were in the previous panel, because national human rights institutions can also play a very important role assisting, technically speaking, civil society organizations in drafting shadow reports. So in this way, national human rights institutions can also provide clarity to the meaning and to the scope of each of the CRPD articles when thinking what to draft under each of the articles. And something that is important also to include, if it's possible, is summary case studies to provide proof of what is being described under articles of the CRPD. It does provide a sense of closeness to those experts who are in Geneva and who might not be entirely familiar of the country context that they're reading of. And case studies can be really helpful in getting to be familiar with those country contexts and with the social context and so on. As I am now in this panel representing the International Disability Alliance, I would add in this topic about shadow reporting that the International Disability Alliance is also providing technical assistance to organizations of persons with disabilities wanting to draft shadow reports to the CRPD committee. And that you can, at any time, contact us in the Geneva office to see how we can engage and support the work that you're doing in drafting shadow reports. I would also pass on to the other treaty bodies, because we usually focus on the CRPD, but as has been mentioned also throughout this week, there are other treaty bodies that have the possibility to receive shadow reports regarding the compliance of the articles under those treaties, those human rights treaties. So as we have seen, the right to family of persons with disabilities can also, we can also think of other treaty bodies that protect that right. The Convention on the Rights of the Child, and maybe the Convention on the Elimination of Discrimination Against Women, and maybe other treaties within the UN system, to which we can also draft shadow reports. And to to summarize with the other mechanisms that the committee engages in and which civil society is able to participate in front of is the other procedures like days of general debate. So this morning we were talking that the Committee on the Rights of the Child is going to engage in one of these days in 2020 regarding children with disabilities in alternative care. So it would be interesting that that if you have the possibility to draft a contribution for that day or even participate, it would be fantastic. And besides days of general debate, there are individual communications that you can present to both the CRPD committee on cases of violations on the rights enshrined under CRPD or under CRC in the case of children with disabilities. Or when there is enough substantiated evidence that there are grave and systematic violations under the CRPD, a request for an inquiry procedure can also be submitted to the CRPD committee. So that would be, in synthesis, how we would encourage you as civil society, as organization of persons with disabilities to participate under the treaty body system at the UN level. Thank you.
Thank you, Silvia. Our next speakers are Campbell from Validity, Validity, formerly known as MDAC, which is an organization using law to achieve equality, inclusion and justice, I believe, for persons with disabilities, particularly psychosocial and intellectual disability. And Anne is here today with Dmitri Bartenev, who is an associate professor in St. Petersburg State University and also a practicing attorney, and has taken many cases, topical cases in front of the European Court of Human Rights and also the UN human rights bodies. So for those of you who are participating in the MOOC court tomorrow, perhaps you might discuss strategy later if you get the opportunity with either Anne or Dmitri. So I'm not sure if you're going to take it from here, but they're going to share this space to discuss strategic litigation with you. So I'll hand you over to Anne first.
So, hi everybody. As Katrina was just saying, Validity has been using the law to advance the rights of people with psychosocial disabilities and people with intellectual disabilities since 2002. When I say people with disabilities from now on throughout my presentation, that's who I'm referring to specifically. We work across Central and Eastern Europe and East and Southern Africa in domestic, regional and international tribunals. And I guess I wanted to speak to you a little bit today about how we approach litigation around the right to family and what are the sort of issues that we come across and how we deal with them. By the time that we meet our clients for the first time, most of them already have no contact with their family members, and connections with their relations have been broken beyond repair at that stage. Generally, our lawyers spend a very significant amount of time developing a relationship of trust with the client and providing practical and emotional support. And this is because the reality is that this is the last human connection that people have left. We litigate direct interventions by states that restrict and prohibit people's right to live with their families. So we litigate issues such as forced institutionalization and denial of legal capacity. And we've had successful European Court judgments in cases like Stanev versus Bulgaria, Chervenka versus Czech Republic, Stukatura versus Russia, which of course was litigated with Dima. And Dima's going to talk to you later about another case we litigated together with him called Kocherov versus Russia. But really, this is only one part of the puzzle. The other part is that we challenge direct separation of children from their families, and Dima will go into details on that. But our cases also challenge the failure by states to act to ensure that people can continue living with their families. Our clients' ties to their family members are frequently shattered because the states fail to provide adequate assistance in the community. Without necessary disability-specific services and information, relatives are often unable to provide the assistance to their family members with disability and can end up acting in ways that harm them and violate their rights. The person with a disability then finds themselves isolated, segregated, abandoned, and ostracized. Assistance from family, whether that be family of origin or chosen family, such as close trusted friends, is the key determinant of whether a person with a disability can maintain connection with their family in their community, or whether they are placed under guardianship and detained in institutions. We have taken, as Validity, several cases that try to tackle the problem before these family ties are broken. One case I want to briefly refer to is a case that we litigated with our Czech lawyer Maroš Matyáško in Slovakia on behalf of a 3-year-old girl with multiple disabilities called Luisa Tomáško. Luisa was considered so disabled by the state that the only assistance that was offered to her was institutionalization. Her mother applied for what is called home care assistance, so some support with cleaning, washing, and eating to be provided in her home. But that support under the law was only offered to adults with disabilities and not children with disabilities. So, together with Maroš, we litigated the case before the Slovak courts and were successful in achieving a judgment where the court required the state to extend this home care assistance to children with disabilities as well as adults with disabilities. And this was a very specific niche issue, but increasingly in our litigation, we're trying to take a holistic approach to how we work with our clients and with their families, so that we look at the client as part of a family and the family as a unit in their local community. For example, at the moment we're working in Uganda with a 14-year-old boy named Perez who has autism. There's absolutely no system of state or NGO support or assistance for him or his family, and as a result, his family has effectively been torn apart. When Perez was 2 years old, his parents took him to the local hospital to seek information and help, and they were given antipsychotic medication for their 2-year-old autistic child. The community that he lives in believes that Perez is cursed, and that his family is cursed. And as he began to grow up and get older, the local children would beat him up and throw stones at him. Eventually, his parents came to the absolute end of their wits, and without having any information or any understanding of the situation, they took the reprehensible decision to tie Perez to a tree. He remained tied to that tree until Validity intervened 2 years ago. 2 months ago, Perez's father killed himself, and Perez's siblings have told us that this was because his father could not handle Perez's situation anymore. Perez's mother and his sister were beaten up by the community and then arrested by the police for murder. Perez and his young siblings were left alone in the house with no parental supervision and no food. The community elders refused to intervene with Perez's stepbrothers when they stole Perez's inheritance and that of his siblings. This was essentially because the entire family had already been ostracized because of Perez's autism. Together with our partners in Uganda, we have implemented a comprehensive strategy to try to deal with this particular case of this particular boy and this particular family in a way that will create change for the wider community. So we have initiated a civil claim before the courts on early intervention for children with autism and access to assistance in their community. We are engaged in the criminal proceedings on behalf of his mother and siblings. We have leveraged specialist services for children with autism. We have run a wide media campaign on radio and television, and we're working with the community to generate community dialogue with the elders, the extended family, the police, the local authorities. How am I doing for time? 12 minutes? Oh, then I better hurry up. Okay, so I had another example which I'll skip, but I guess my essential point is that families, whether they're biological or chosen, are at their foundation about connection between human beings. And connection is at the heart of humanity and of what it means to be human. In general, our society doesn't promote this. It prioritizes superficial and electronic contact over eye contact and face-to-face meetings. Our societal structures are constructed around rationality, around logic, around facts, and the so-called rational man is the standard that we tend to hold ourselves to. Emotion, connection, and understanding are often forgotten or downplayed or relegated to the so-called private sphere of life. There is no private life in institutions. Laws affecting people with disabilities too often restrict or deny opportunities to develop connection. Laws prohibiting marriage, prohibiting adoption, removing custody of children from their parents, laws that allow forced contraception, forced abortion, forced sterilization, these all take away our very ability to connect. Laws and policies targeting people with disabilities too often ignore the importance of family assistance and fail to protect existing informal supports or promote their development where these are lacking. The law needs to catch up with our fundamental understanding that we all instinctively have that family and connection are core to our dignity and our development and our survival. I will leave it at that for the moment, and I'll hand over to Dima to speak in more detail about his litigation with Validity in Russia. Thank you.
Good afternoon, everyone. My name is Dmitri Bartenev. I was introduced as an associate professor of international law, but have primarily identified myself as a human rights attorney and have been working with Validity, formerly known as MDC, Mental Disability Advocacy Center, for almost 15 years, advocating cases involving people, human rights of people with disabilities. I wanted to continue on what Anne has been saying with regard to the importance of protecting family ties and the family values, so to say, from the disability perspective. And I would like to illustrate this with one successful case, which was our experience on strategic litigation in Russia. In general, as Anne summarized, Validity has a long history of strategic litigation involving various aspects of family rights, and many of our cases, they dealt with legal capacity issues. As you were discussing early in this summer school, there is an intrinsic link between legal capacity and family rights. Some of the cases relating to legal capacity, they challenge the legal frameworks which have been determining the attitudes, the legal attitudes towards people with disabilities for decades in many countries. And those cases, they put the end to these restrictive legal frameworks. In Russia, we had successful cases challenging plenary guardianship as the only legal framework, and other restrictions which are automatically placed on people with disabilities. But this case dealt with another angle of stigmatization of people with mental disabilities. So it is the case of the officially it's called Kocherov and Sergeyeva versus Russia. So Kocherov is the name of the man who's in this picture, and his wife is Natalia Sergeyeva. So they met when they were living at the social care home for people with mental disabilities. They made a family, and the institution was kind of tolerating their relationship. They even secretly married, but so they lived in this like hospital-like institution with over 1,000 beds. So it's one of the largest institutions in Russia, but there are actually quite many large institutions like this. And they wanted to have a kind of real family, so they wanted to have a child. And in 2007, Natalia gave birth to their biological daughter, Anna, who was, and because Natalia was lacking legal capacity, she was deprived of legal capacity by a court order. The child was automatically removed from her without even inquiring whether she could physically, like factually, take care about her daughter. And the father was denied recognition of his parental link because the mother is legally incapable, and she could not legally indicate that her partner was actually the father of the child. So the child was the girl was placed under custody of the state, and that's where the kind of the story began, and that's where they referred to our organization. So they wanted to actually restore their parental link with the child, and they wanted to take the child to take care and to live together as a family. But the state denied this on the pretext that the mother was lacking legal capacity, and the father was living in the social care institution, and that's why he was kind of automatically presumed of being unable to take care of his daughter. So even though at some point the father managed, with our help, to have a social housing outside the institution, which was assessed as being perfectly fit and perfectly organized to ensure the living with the child. But even despite this fact, he was denied his parental custody. So we applied to the court seeking restoration of his parental authority. And the court, after assessing various reports, even psychiatric reports which suggested that he was actually perfectly capable of being a parent, but the court still denied his application, stating that first, has the history of living in the social care institution, and that's why has no experience in taking care of a child, as if everyone else has this experience in this society. Secondly, the court said that his wages, despite the fact that he was employed, that his wages were below a certain level, which would be desirable in this situation. And finally, the court argued that because the mother was lacking legal capacity, it would be kind of dangerous for the child to live with her in the family. So we went to the European Court of Human Rights after exhausting all the domestic remedies. So all the Russian courts, they confirmed this decision. And our legal strategy was to argue that that this case is not only about restricting parental rights, but it's actually about discrimination and assumption that a person with mental disability is presumed by the state as automatically lacking capacity for caring of his child. Secondly, we wanted to invite the European Court of Human Rights to interpret the existing core human rights of the right to respect the family right, family life enshrined in the European Convention. We wanted the court to interpret it through the CRPD, so using the standards enshrined in the United Nations Conventions on the Rights of People with Disability. And finally, we wanted to the court to address the issue of potential conflict of rights. So the rights of the child, so to say, the right of the child, and this concept of the best interests of the child, which is sometimes used, as in this case, to deny parental custody of the parents, because their custody is is viewed as against the best interests of the child. So on the one hand, and on the other hand, the conflicting rights of the parents with disabilities to have their family rights respected and to be provided with necessary supports if the state considers them as not being fully capable of taking care of their child, to provide them with necessary supports to ensure that they can live as a family. So the court finally, the European Court issued its judgment in 2013 when the child was already 6-year-old, and just before the judgment was pronounced by the European Court of Human Rights, the Russian courts finally agreed that the parental custody should be returned to the parents. So it took us 6 years to argue this case and finally to return the child to their family. The parents made enormous efforts to continue their relationship with the child despite all the restrictions, and I think that partially it was because of this legal support. And we see that the strategic impact of this case is not purely this legal importance, as Anne was suggesting, it's also about the personal connections. And the case, the final outcome of this case, which I will briefly summarize the legal outcome of this case, but it's not only about the legal victory, and that it's not only about the European Court of Human Rights highlighting several legal points, but it's also actually about the empowerment of people with disabilities. The case was widely publicized in Russian media, and I know that it was relied upon on various occasions, not only in Russia but also internationally, as a basically first case in the European Court of Human Rights practice dealing with the parental rights of people with mental disabilities. In terms of its legal impact, the European Court of Human Rights remained silent, unfortunately, on the links between the European Convention of Human Rights and the CRPD, but de facto it acknowledged that the case is about discrimination, and I really invite you to read the dissenting opinion of one of the judges in this decision, who disagreed with the majority of the bench, and the judge Helen Keller, she said that despite the positive judgments, despite the judgment in favor of the applicants, the court should have addressed the issue of discrimination, and the court should have emphasize its approach to the legal tests or legal standards used in the discrimination cases, meaning that when the state authorities, they deal with the situation of people with mental disabilities, the approach which the European Court of Human Rights adopts is that this is a suspicious ground for restricting parental rights. And in reality, it happens vice versa. The states would use the mental disability as a pretext for automatic removal or restricting human rights, be it parental rights or other rights. The European Court of Human Rights says that as long as the state deals with the case involving people who have been traditionally discriminated in this society, the state should be aware of these attitudes and should actually take positive measures to overcome this stigma, and not rather than using the mental disability to promote this stigma and to remove parental rights. The other thing which was really missing in the European Court of Human Rights judgment was the issue of supported parenting. We were arguing in many details that if a state considers this family as not being fully capable of caring for their child, the state should provide supports, not to the child who had no disability, but to the parents with disabilities, in order to respect their right to raise their biological kid in the family. Still, despite the fact that the European Court remained silent on the issue, the case was kind of perceived by the legal and activist community as de facto acknowledging this positive duty of the state to provide parents with necessary supports for ensuring their right to family life. Thank you.
Yes, we'll do it from here. It might be easier, wouldn't it? Yeah.
I'll give you this microphone. So.
Yeah.
Okay. I'm just going to introduce Roger Lewis, who's going to talk about direct action. Roger is a member of the National Steering Committee of Disabled People Against the Cuts, known as DPAC, for 8 years, and he's taken a leading role on many of their direct action protests in London and elsewhere, and has become one of the lead speakers for DPAC. So he's going to talk to you today.
Thank you for that introduction, and thanks very much, Katrina. I'd just like to start with a little explanation of DPAC, my organisation, and who we are, and in particular with a reference to language, because you'll hear me referring to disabled people, not people with disabilities, and there's a history to that and a reason. I just want to sort of go into that, but it'll help you understand who we are. We base our tradition on the development of the disability movement in Britain. Goes back to, well, goes way back, but certainly back to 1978, with an organisation called the Union of the Physical Impaired Against Segregation, UPIAS, headed by a gentleman called Vic Filkenstein, who's a particular hero of mine, and UPIAS came up with this definition. They used the terms what is impairment and what's disability, and their definition is what is central to what we call the social model of disability in Britain. And that's that impairment is it's functional, it's descriptive. I've got a visual impairment. People can have a physical impairment, a loss of a limb, or a loss of function to a limb, or cognitive ability, or either acquired or congenital. But disability is the exclusion we experience because of those impairments as a result of socially constructed ideas, the exclusion from the environment, the exclusion from access to work, and from negative social attitudes that have arisen as part of our separation from society historically, moving away from inclusion in society and being placed in institutions and long-stay hospitals and incarcerated. And UPIAS was fighting on that basis. It was fighting Union of the Physical Impaired Against Segregation for the right for independent living, to get liberated from the long-stay hospitals, institutions, residential and nursing homes. We stand in that tradition. It was developed further by a gentleman called Mike Oliver, a disability academic who sort of widened that definition, and also then in the 1980s and 1990s, an organisation called DAN, the Direct Action Network, that we're particularly indebted to, who went out into the streets using direct action to raise the issues of exclusion for disabled people, fighting for our right to access to public transport, fighting for our right to access to the physical environment and public services and buildings, and also fighting for rights of a recognition of our exclusion from work and the need for work-related disability benefits, but also to accept and understand the additional costs of being disabled and to have non-work-related disability benefits. And they were chaining themselves to the old buses, you know, the old London buses, what we call the route masters, completely inaccessible to disabled people, but also campaigning direct action out on the streets over all of these other issues. And they won a number of different important reforms, not perfect by any means, but a number of huge reforms in the right for an independent living fund that was there and is there to allow the people with the most complex impairments to get out of the hospitals and live independently in their own homes in the community. A grant that was delivered nationally, so there wasn't any cost to local authorities where you know, services vary so widely, and also a non-related work benefit called disability living allowance, which was there, non-means tested, which was there to accommodate the additional costs that disabled people felt. Then what happened? We had 2008 and the financial crisis, the international financial crisis, and the introduction of austerity. This has been used in Britain as an opportunity to push back all of these advances in the name of having to save money. But behind it all has been an intention to roll back the welfare state and to push back on all of those advances that we won back in the 70s, 80s and 90s. And this is what DPAC's been facing up against. What happened was the Tory government, the Conservative government, when it came in 2010, it had started slightly before that, but let's use that as a benchmark. They brought in a private company called Atos to conduct what are known as work capability assessments, assessing whether disabled people were fit for work or not. And we quickly found out that those work capability assessments were disadvantageous, that they were biased, that they were incompetent, and they were out there to actually sort of do huge amounts of harm to people. As an example, the assessment centres themselves very often well away from where people live, with inaccessible transport and real problems, were also inaccessible as buildings. Yet disabled people were being instructed to go there, often with letters. They got there only to find the assessments had been cancelled. But if they didn't hear, and this often happened, and they turned up late, then they were told they were going to lose their benefits. The assessments themselves, just as an example, you arrive at the benefit centre and the person will say, well, did you get here okay? And how are you? And of course the natural answer to that is, yeah, I got here okay. Yeah, I'm fine, thank you. You're being assessed already. And they're already finding you fit for work because you got there okay and you're feeling okay. The functional assessments themselves, this is how ludicrous they are. They're a question of, can you pick a pint of milk up off the floor? Can you lift this empty box? Can you put a pen in your top pocket? Can you sit in a chair and press the buttons on the computer? Those were the assessments that were being placed with people saying you can do that, you're fit for work. We've got occupational therapists assessing people with complex mental distress conditions. We've got physiotherapists assessing people with sensory impairments. And this for a £20 million contract. So we knew we were in for trouble, and that's what DPAC was set up to tackle this and take it on and to raise the reality of what's happening out there. 2012, the Paralympic Games in London. Who's sponsoring the Paralympic Games in London? Atos. Who are Atos actually? They're a French IT company actually. But their parent company is an American insurance company, a giant, called UMA. And UMA are known in the United States. They've been banned from several states in America for disability denial. And they underpin this approach to disability. It's a conscious attack to push back the advances that we made and the recognition of the disadvantage that disabled people experience. So 2012, the Paralympic Games take place in London. We took advantage of that in the week leading up to the Games to stage a whole week of direct action. On the Wednesday, we staged a funeral procession to the Atos headquarters in central London because we knew already there are people who are dying as a result of these work capability assessments, particularly people with mental distress who have been driven over the edge and taken their own lives as a result of the inhumane way they were being treated. And then on the Friday, the opening of the Paralympic Games itself, We took a group of people, I was proud enough and lucky enough to be involved in it, that occupied Caxton House, the home of the Department of Work and Pensions, which oversees the work capability assessments, which was responsible for employing ATOS. We did that because it got us national news coverage, it got us international news coverage. It put what was happening on the agenda. It got me on News 24 that evening during the opening of the Paralympic Games. I spoke just after David Cameron had spoken in the stadium on News 24. That gave us the coverage we needed to publicise what was happening. We kept that up. 18 months later, Atos were forced to give up the contract. We'd ruined their reputation. We destroyed them, their share prices went down to the floor, they couldn't employ staff, they were playing around with trying to change their names. We showed that disabled people could stand up and fight back, and we weren't just going to be pushed around and humiliated. The government thought we were an easy target. We showed that by standing united together we weren't going to be. 2016, the government wanted to close the Independent Living Fund. This is the one that keeps the most complex people with the most complex impairments out of institutions. What we had to do there, the sanctuary, a grass area next to Westminster Abbey. If you don't know London that well, Westminster Abbey is quite adjacent to the Houses of Parliament. We occupied that area of ground. We were going to put tents up and stay in there for 3 days, but the police managed to stop us putting the tents up. But we occupied that place for 5 hours. 5 hours, 50 disabled people. To put this in context, a week before, 50,000 people had marched through London against austerity in a traditional demonstration. All the banners, the trade unions, the marching, the chanting. No coverage whatsoever in the national news, no cover whatsoever in the London news. 50 people occupying the sanctuary area. 300 police, including riot police and bizarrely a tactical arms police response unit. To explain that one to me. But what that got us was national news coverage. We were announced off the stage at Glastonbury, the biggest musical festival in Europe, with over 150,000 people attending there. It got us national news coverage on all the TV networks and in the mainstream press. That's what it takes to get our issues across into the public. What it did was it pushed the government back on instituting the attacks on the Independent Living Fund for 2 years. But we haven't won everything. We've still got to continue and fight back. A year later, we were occupying Westminster Bridge, the bridge that goes from the south side of the River Thames over directly to Parliament. A 25-metre banner drop with no more deaths from benefit cuts, highlighting what was happening to disabled people. This is what our organisation has been engaged in and will continue to do with the introduction of universal credit, which is yet another attack on disabled people, hugely disadvantageous, but also leads into attacks on other people. It's got attacks on women with more than 2 children, attacks on pensioners where one is below pension age and one is over pension age. We can begin to unite our struggles and show that we need to defeat this government and what it's doing by standing together and standing united. That's the tactics we'll be using with direct action, and we will. If the government is going to continue to destroy and break our lives and take our human rights away, we say we have the right to break the law and do whatever it takes to fight back. So we do that, but we don't, that only involves a small number of people. And it's a tactic, not a strategy. The strategy is wider than that. It's trying to work with every other group that's disadvantaged, because we knew with their attacks on us, they were going to turn their attention to other groups and how right we are. With the attacks on migrants, with the attacks on people from Muslim backgrounds, we want to stand united and make sure they don't divide us, and we stand all together on that. So that's an important part of our tactic. But we also do lobbying and we do traditional campaigning. And we've done a lot of work with the United Nations behind the scenes. The CPRD, the people are talking about, DPAC were involved in inviting them to Britain to go through what was happening. We got them in touch with the people who have been directly affected. And we got that result that the UK government has been found guilty of grave and systematic abuses of the rights of disabled people as a result of benefit reform. The only country in the world that that's actually happened to. This is the shame of this, what's happening in my country, in Britain, right at the moment. And then there's a second report which has just been issued in April this year, which goes wider and looks at the extent of poverty and the increasing the gap between those at the top and those at the bottom. 14 million people in the 5th richest economy in the world now living in poverty, with an estimated 41% of children going to be living in poverty by 2021. This is what's happening, and it's a result of what this government wants to do, which is to destroy our welfare state, destroy the National Health Service, to privatise it and move it to an American model. And that's what they want to do, not just here, but systematically around the world. We know with the World Trade Organization, with the IMF, the introduction and the use of of you know, the controls of states right around the world and how to spend their money, the structural adjustment programs. This is what we need to do and unite those struggles. We're going to continue to do that, using all the tactics, direct action, where and when necessary, but linking those struggles and using every other means at our disposal in terms to fight back against what this government's doing and a failed economic system around the world, this wrecking disaster, whether it's with economic driven climate change, whether it's with the further use of imperialism, destabilising the world, with the wars against Iraq, with the destabilisation that's looking towards escalating in Iran at the moment. We stand in the tradition of people fighting back, whether it's in Sudan, as they're doing so courageously at the moment, in Algeria, or with all of those. We stand all together with migrants, who all too often are disabled people themselves who have been dispossessed and thrown out of their own countries, destabilising their independence, destabilising their entities, their identities, creating mental health distress as well as physical impairments. War, disease, climate change create disablement. We need to fight back against all of that. So I'm thanking everyone here and the organisers of this event for inviting me to come and speak to you all today and tell you a little bit about what we're doing. The one thing I know is united we're stronger, and our message to everyone here today is solidarity.
Thank you, Roger. I'm going to open up the floor to questions, to Q&A. We have at least 20 minutes anyway, maybe